Sierra, if anyone would like to speak on any topic on the agenda tonight, there are public speaker slips in the back if you could fill one out. So the time is now 6:31. I'll call this meeting to order. Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Mayor Lofgren.
Present.
Mayor Pro Tem. Here. Sorry, I was trying to can't do two things at once. Trustee Counterman.
Here.
Trustee Doherty. Trustee Jeffrey. Here. Trustee Morris.
Here.
Trustee Brock. Thank you. That's it.
So red.
All right. That is supposed to mean on now, so. Okay. First item on the agenda is the approval of the agenda. Do I have a motion?
I move to approve the agenda with the addition of action item 7E, an engagement, to add an engagement letter with Setter Vanderwell LLC regarding library law services.
I have a motion. Do I have a second?
Second.
I have a motion and a second. All in favor say aye.
Aye.
All opposed? Motion carries. The agenda is approved with the addition of that action item. Next item is okay, so next item on the agenda is audience business, and we had one speaker slip from, looks like Eddie Williams. If you could come up and state your name and your address, and then you can share your thought.
I'm a resident here in the town of Lockwood, and last winter when we had that big windstorm and snowstorm, it knocked down my neighbor's back fence. 3 days later, I finally put a little note on the door saying, hey, could you like to put your fence back up and nail it back up properly? He left me a little note saying, I'll lay the fence up, hopefully it won't blow over, and I'll nail it back up a little later. Well, it's been about 3 weeks now, and he hasn't done anything. Last Thursday, I came in here and talked to the code enforcement guy. Is his name Andy? Is that his name? Okay, to see if he could go do something, and he says, well, all you could do is come to the little meeting and see if they can approve to amend something called fence maintenance, and it's 16 number 10-30. And then that way he can go over there and talk to the people about nailing their fence back up. And that's all I got to say, because I've been nice enough to ask them to nail it back up, and they don't seem to do it. I gave them enough time for the weather to clear up, and they don't seem to do it. So that's kind of what Andrew told me to do.
Okay. We will note that concern, and we'll have staff look into it. And then if there's action we need to take or can take, we'll look at that in a future agenda. Thank you.
All right,
and
thank you.
Just for the record, can you state your name and address just so our clerk has it?
Eddie Williams at 645 Willow Drive, Lockwood, Colorado, 80603.
Thank you.
Thank you.
Okay, that all I got to do?
Yep, that's it.
Okay, thank you.
That was the only slip I had for, thank you. That was the only slip I had for public comments. Is there anyone else who wishes to speak? Okay, the next item on the agenda is the consent agenda. Do I have, for the benefit of the audience, the items on the consent agenda are the payment approval report in the amount of $603,471.70 and the March 19th, 2019 minutes. And before I take a motion, there was one correction I meant to tell you about. You left Ms. Huerta Cruz's approval on there in error, because that was 2 meetings ago. It was like you forgot to take it out or
I
something.
didn't take it out. Okay, I can fix that.
But with that amendment, do I have a motion?
I move to approve the consent agenda with the noted amendments.
Second.
I have a motion and a second. Roll call, please.
Trustee Jeffrey.
Yes.
Trustee Counterman. Trustee Ott.
Aye.
Trustee Morris.
I'll abstain due to absence last meeting.
Mayor Lofgren.
Yes, and the motion carries 401. Next item on the agenda is action item A, the events committee application for Mae Westcott. Ms. Westcott, if you want to come forward and say a few words and Tell us why you're interested in the events committee. You don't have to say much, just your name, address, and,
I'm Mae Westcott, and my address is 2019 Fletcher Avenue, Lochbuie, 80603. I'm just interested, we moved up here from Aurora about 3 years ago and didn't really understand that Lochbuie was a small town. And as I've come to understand that, I've kind of fallen in love with that notion, and I like the idea that I can be involved in city government, and this is a way to do that.
questions or comments from the board? Trustee Morris?
I've known Mrs. Westcott for a couple years and have found her to be a woman of exceptional talent, great leadership ability, and a commitment to community involvement. She's going to do a great job. We're lucky to have her, first of all, in the town, and lucky to have her involved with the events committee, and good luck, May. Glad you're involved. Thank you.
Okay, with that, I will entertain a motion.
I move to approve Mae Westcott to the events committee.
I second.
In a second, all in favor say aye.
Aye.
All opposed? You are appointed. Okay, next item. Next item is action item B, ratify the Lochbuie Center final plat. Mr. Stamey.
Briefly, Mayor, then John Splain is here to represent the applicant. No, we have been working on the Lochbuie Center subdivision and final plat, which has been approved administratively. During their title work by the proposed purchaser of this property, the title company had a couple of questions, so John Splain, as applicant, is going through this additional step to address those concerns that the title company may have, and I'll let him speak to that tonight.
Good evening, Mr. Mayor, members of the board. I'm John Spillane, WCD Corporation. Our address is 8301 Prentice Avenue, Greenwood Village, Colorado 80111. Thanks, Steve, and he's correct that basically we are asking for the town board to have this hearing tonight to ratify the final plat for Lochbuie Center, essentially to take care of a correction to the mineral notices that were sent out in connection with the initial public hearing. One of the mineral owners was not picked up in the title commitment and didn't receive a notification, and the feeling was that we didn't want to have anyone who might be affected by the final plat not have an opportunity to be heard. So we scheduled this public hearing and sent out the notices, and we sent the town a certification of the notices under the notification statute. And so our intent here tonight was just to simply give anybody who might be affected by the final plat the opportunity to be heard. And then we would ask for the board to ratify the plat as it has been approved administratively by the town.
Is there anyone here to speak on that? Seeing none, I will entertain or any questions or comments from the board. I will entertain a motion.
I move to approve the Lochbuie Center final plat.
Second.
I have a motion and a second. Roll call, please.
Mayor Lofgren.
Yes.
Trustee Ott. Trustee Morris.
Aye.
Trustee Jeffrey.
Yes.
Counterman. Thank you.
Carries 5-0. And before I move on to action item C, I noticed that we had someone to speak on action item A concerning events. Ms. Lander, if you would like to come forward.
Ever.
I'm Lois Lanter at 1006 Lilac Drive in Lochbuie, 80603. I have been with the Lions Club in Lochbuie for 20 years. It's called the Southweld County Lions Club, which most people don't even realize that we have one. And we've always put on the 4th of July breakfast. That was our main fundraiser, and we made enough money to last us through the year with all of our donations that we give and the help that we give to the community, to the state, international, and anybody that really needed it. We were able to help them with that one fundraiser. Our club is now down to 6 members. 4 of them work. One is a disabled person that she cannot speak or hear. So we can't ask her to do a lot. We have to do it all by sign language, and there's only one person in the club that can sign with her. But she does help. So when David Ott called me and asked if we were going to have a 4th of July breakfast this year, I said, no, I don't have the people to do it. Last year we didn't have it either because we didn't have the people to do it. So I'm understanding that you might be wanting some information if you go ahead with the events thing of putting on a 4th of July breakfast. I would be more than happy to answer any questions that anybody has about how we went about it, our sources of where we got our information and so on. And all of it was, we rarely spent, well, first I better go back. We served about 150 people every year. We rarely spent more than about $30 on that 150 people because everything was donated either by the community, places where we went and asked for help. A lot of the members donated things because they were unable to pay their dues sometimes. So we said if you worked the project and you did donations of whatever you could, we would keep them in good standing, and they were in good standing. We have never missed a year in those 20 years of not being in good standing with International Lions Club. So I am available to answer any questions that you might have, and if you form a committee, I would be, I don't know if I want to say I'm going to be on that committee, but I would be more than happy to help.
I talked to Lois as we were discussing having a 4th of July celebration, and she has a lot of stuff left over from their, you know, hardware, utensils and that kind of stuff. So I thought maybe we could partner with the Lions Club to do our 4th of July celebration and get a start on a pancake breakfast. And having cooked several breakfasts for the senior center, I would be more than willing to jump in and, you know, help out on the July 4th celebration. My race isn't until the following weekend, so I'm here.
So I think what I will do is direct you to talk with May tonight and exchange some information. And Sonia Huerta Cruz is, I think, going to be the chairperson of the events committee, at least initially. So maybe May can help build that connection.
Okay, I would be more than happy to do that.
Great.
So,
Thank you, Lois.
Thanks, Lois.
Oh, really, it started out with asking if we were going to have the Easter egg hunt.
Yeah, that's right, it did, yeah.
I said it's kind of short notice on that, and no, we were not going to do it because we had the understanding about, I don't know, when was Candy on the board? Yeah, well, that's when she told us that the Lions Club would not be doing the Easter egg hunt anymore, that either she or the town would do it, so.
Thanks for your input.
So now we will move on to action item C, which is the approval of the amendment to the Water Resource Credit Agreement for Silver Peaks East.
Good evening, Mayor Lofgren. This is a simple amendment. We signed a water resource credit agreement with the developers last year, and they just need a little bit more time to work out the details with the buyer of the property. They've asked for an extension of the closing date under that agreement to move it from April 18th to May 20th. We have no objection at our firm, and Chris Sanchez has no objection to that extension. That would work fine for us in terms of closing on the water dedication to the town and the payment of the fees associated with that. So we support that and ask you to approve that amendment.
I will entertain a motion.
I move we approve the amendment to Water Resource Credit Agreement for Silver Peaks East, which changes the closing date from April 18th, 2019 to May 20th, 2019.
In a second, roll call, please.
Trustee Morris. Mayor Lofgren.
Yes.
Trustee Counterman. Trustee Jeffrey.
Yes.
Trustee Ott. Thank you.
Carries 5-0. Thank you. And the next item is the Blue Lake Ditch Agreement. Mr. Sanchez.
Thank you. Again, my name is Chris Sanchez with BBA. I prepared a report that is in the board packet that I'm going to intend to briefly walk you through. For clarification, this report was prepared on behalf of the Blue Lake developer and builder, Mark Bush and LGI. Specifically, we were retained to help address the question of shallow groundwater concerns at Blue Lake Filing 1 in the context of, one, whether or not it's necessary to line a portion of the West Burlington ditch, which the developer agreed to do in an agreement with the town, and two, whether or not an existing underdrain out at Filing 1 should be removed. There was discussion and I think an informal agreement that that underdrain that was constructed within the residential development was a temporary structure that should be removed after the ditch was lined. One of the fundamental findings of my report is that the underdrain should remain in place for the protection of the homes. And that's because the concept that it should have come out in the first place was based on a finding or an assumption that the shallow groundwater concern would go away once that ditch segment was lined. And that's just not something from a groundwater science point of view that we agree with, for a couple reasons. The most significant of which is that the lining of the ditch will reduce the groundwater flow out there, but there are many other sources of groundwater working their way through Blue Lake Filing 1, including the Spear Canal, which is located farther to the west and is a much bigger ditch system. In other words, lining a segment of the West Burlington ditch just isn't going to solve the concern of groundwater being present at that location. It's still going to be there. So the question then becomes, is the status quo condition acceptable out at Blue Lake Filing 1? And we believe it is, based on monitoring data that the developer and builder maintain at that location. We went through a process of interviewing the builder, the town public works staff, and looking at their geotechnical reports to confirm whether or not the status quo condition out there is a concern to the existing homes. And we found that there are no concerns as it exists right now at Filing 1. And the status quo condition with respect to water levels appears to be acceptable. We do remind the board, though, that the underdrain does feed the existing retention pond out there, and you know, that does remain a concern, and you know, the long-term obligation of that pond with respect to water rights considerations and you know, other issues is something that I think needs to be managed and accounted for with respect to who carries that long-term responsibility for that structure. Again, the report is in your board packet. I'm available to answer questions that you may have with respect to what we found, and Mark Bush is here if there are any questions for Mark as well.
Anything from staff on this, aside from Mr. Sanchez?
By way of background, I think, if you recall, we were under an agreement with the developer, actually the builder out there, LGI. So it's an agreement between the town and LGI where they posted security, and I apologize, but I don't have a copy of it with me, but it's security in the amount of $350,000 plus or minus dollars, which was the engineer's estimated cost to either line or relocate portions of that West Burlington ditch. And we entered into that agreement because we had had an opinion a few years back from, I think it was the RG engineer, that indicated that he felt like that solution was required in order to address these groundwater concerns. But I think further analysis has been presented to you. But that agreement initially expired, I think, in the December timeframe, but we went ahead and extended that through June. So right now we have an agreement and we have a letter of credit in our vault here from LGI for approximately $350,000. So depending on what this board wants to do, what we would need to do is come forward with that agreement and ask you to agree to amend it to terminate it earlier and release the security as opposed to terminate it and then take the security and line and or relocate that ditch ourselves. So,
Are we looking for that action tonight?
LGI is anxious to get its letter of credit released, so I think LGI is looking for that to happen, but I do think I need to, depending on your direction, probably bring back an amendment to the agreement that just says we release them of all obligations to do anything with the ditch, if that's what you're inclined to do, and that we'll go ahead and release the security, so.
Questions or comments from the board? Trustee Morris.
Yeah, thank you. I appreciate the additional science and research that was been done into it. I do raise an eyebrow. One study said it was necessary, and then this one, which appears to be much more comprehensive and more timely and maybe relevant, says that it's sufficient as is. Couple questions. If we move forward with this, does the ditch still get relocated, or has that been done, or does it stay in place without the lining?
The proposal as it exists right now, and Mark can address this if I fail to address it adequately, but they're essentially proposing to leave it as is now.
Turn it into a park.
Correct.
Do you know off the top of your head, in the report it talks about, it mentioned that a portion of that underground water comes from the Burlington ditch, but were you able to quantify it at all? Do we know?
We didn't
Roughly how
specifically quantify it. I did look at a comparison of the relative ditch capacities between the West Burlington ditch and the Spear Canal. And you know, the contribution based on the capacity of those ditches would suggest that significantly more of the water comes from the Spear Canal than does the West Burlington. I say that acknowledging that there are also other sources, including irrigation return flows and precipitation recharge and those sorts of things that occur out there as well. If I had to guess the percentage of water that's coming from the West Burlington now, it's probably on the order of 15 to 30% of the water supply out there. So lining of the ditch would reduce the groundwater at filing one, but at the end of the day, it probably only results in a slight difference in water level change would be my educated guess. So.
That, another question, could you maybe take a minute and enlighten us a little bit more about the under drain system, particularly how long would that potentially operate for? Is there a risk of it clogging or getting backed up or creating problems in that area?
Sure, you bet. In my view, it should be operated and maintained on a permanent basis. I have not looked at the specific construction of it to know what it's going to take to maintain it, but typically those structures are constructed in a way where there are clean outs, just like a sanitary sewer system where you can get in there and wash them out from time to time. There is a potential for maintenance being needed. And yeah, it should be maintained so that it functions effectively on a permanent basis. One of the suggestions that I had in the letter was that the monitoring wells that are currently measured by the developer should be maintained on a long-term basis so that periodically be checked and to confirm that that the system is functioning properly. Another way to check if the system is functioning properly would be to look at the discharge to confirm that water continues to flow out of that system, but unfortunately it discharges to that pond in a way where the discharge is either underwater or under a bunch of riprap, and it's not feasible to get in there and take a look at it. So, but the monitoring wells should be an effective way to gauge the continued performance of it.
Speaking of those wells, I see the report, the measured depth, the shallowest measured depth of water. How frequently was that checked?
Monthly, I believe. I think those are monthly measurements that we have. Okay, so every 2 weeks, yeah. I mean, it's a decent data set that we have from those. To the best of my knowledge, well, Mark, can you speak to the plan for ongoing monitoring? I'm not familiar with whether or not there is a specific plan to continue monitoring.
I think that, I agree with that. Well, anyways, Mayor, trustees, Mark Bush, Concord Partners, 905 West 124th Avenue in Westminster, 80234. I don't really have a whole lot to add because I agree with Chris's analysis and his suggestions. And our intention is always to keep our monitoring wells out there in partnership with LGI, obviously, and you know, keep track of the situation going forward.
So I think there's three issues here. If the board is willing to accept the science and leave the building to pitch as it is and allow the agreement to remain in place, I think the three issues that have been identified is who's going to maintain functionality for that, the ongoing perpetuity functionality of that agreement. Also the monitor to ensure that that's actually working and being effective. And then there's issues of the lots, combining those lots that are right alongside it.
Sure.
We talked about that in the meeting. So I guess, the mayor has to really take action on this tonight. I think the amendment to this agreement would need to take place. And I'm kind of looking at you, like, who would be the party that would take on that obligation? The town would to, and then it would fail.
Well, I've actually been working with LGI on it. LGI is the effective owner of the underdrain. You know, my suggestion to LGI, and they're moving forward on it, and Casey's here, he's with LGI and handles all the project out there for LGI's purposes, but my suggestion, and LGI's working on it, is to transfer that underdrain out of LGI's name into Blue Lake Metropolitan District Number 3, which is an ongoing permanent entity that would accept the maintenance obligations associated with the underdrain as well as the ownership, and also the responsibility to do the monitoring of the piezometer. Take it out of the developer, who we all hope someday will be long gone, and put it into a permanent entity that would then accept that responsibility. You know what I could also do, Maureen, maybe for the next,
So what we
prior
could
to the
do is
next-
exchange an IGA with Blue Lakes Metro District Number 3 in exchange for the town's agreement to release LGI of all of its
yeah, I
obligations.
think that's a good way to put it, actually.
How about the lot, the combination?
Well, we're fine, our company owns the lots that and I don't know what I was thinking about when I platted over top that ditch in the first place, 2004, but that's here nor there. But, you know, Maureen and I chatted about either we could do a permanent deed restriction on those lots as permanent open space. What we'd probably do is then transfer the ownership of those lots to the homeowners association. They would maintain it like they do all the other public parks out in the community. Maureen also suggested maybe we might do a replat and put those lots into a tract effectively. I don't have a preference. We could do it either way, and I was thinking that maybe Maureen, if we could bring it back next time, one thing we could do is we could prepare those documents for that next meeting.
Yeah, I think that just to protect the town, we're going to want to say that we're not going to be willing to release the letter of credit and the responsibilities that we currently have in our favor unless and until we get an application. I prefer to see it, just do a replat, which can be handled administratively because it's just a small little lot combination. So if you can get working on that, and then an IGA between the town and Blue Lake Metro District Number 3 for ongoing maintenance of the drains, I think would be preferable.
Chris had a concern about the retention pond, long-term viability of the retention pond.
Well, that's a pretty large issue. The town has an IGA between the South Beebe Draw Metropolitan District to provide all the stormwater services for the area. Ultimately, the way that agreement works is that South Beebe Draw is responsible for building regional stormwater infrastructure. Our project pays them fees every building permit. Our homeowners also pay them maintenance fees every year, but they haven't been providing any services to us. And they haven't been looking at developing. Ultimately, what will happen is that pond will have to get refilled back in we'll put together, kind of more of a traditional retention pond, and then it'll release across County Road 37, and then the ultimate outfall will be the BB draw. But I think that that's it's just not on South BB's radar.
Chris just mentioned the long-term, when he mentioned the long-term stuff, he didn't mention the retention pond.
Well, right, I mean, if that's the long-term solution, that's probably the best long-term solution, filling that in and making that water drain elsewhere.
Right.
But in the meantime, it is a potential obligation that,
Well, right now, with the way we have the retention ponds ownership, it's in Blue Lake Metropolitan District I want to say District number 2 or number 1, and they're the owner of it, ultimately responsible for the maintenance of it, et cetera. We hope that South BB draw comes into that particular basin in, say, the next 5 years, and develops the outfall system that we need to drain to. So it's retention now, future detention. Sure.
Further questions or comments? Trustee Counterman.
I'm sorry, go ahead. Trustee.
Make sure I understand this correctly. I'm looking at this figure 1 and I'm seeing that the ditch comes very close to the houses there that are planned. Now, you're talking about doing something with those few lots there along the ditch?
Yeah, if you look at Chris's exhibit, you're talking about the aerial photograph there?
Right.
What we'll do is, we'll do a replat based on Maureen's suggestion, and we'll put that into a tract, effectively a dedicated open space tract. So we'll effectively congregate those 7 lots into one large tract and dedicate it as open space.
Thank you.
Any other questions or comments? So I think, and if you disagree with me, please make it known, members of the board. The direction that we can give staff tonight is to work out an agreement consistent with the conversations we heard tonight, and bring it back here for formal approval.
yes.
I'm seeing lots of nodding heads, so I think that's your direction. Thank you. Next item on the agenda is the discussion items. Discussion item A, the non-tributary well site. Oh, yes, that's right. Action item E, the engagement letter. Mr. Hahn.
Direction of the board at a recent meeting, I engaged the law firm of Setter and Vanderwall. They're well-known in Colorado for representing library districts and local governments interested in establishing their own libraries to assist the town in our goal of trying to get a library facility in town. They've done some initial analysis. I've discussed that with the mayor. And we are going to invite them back to hopefully hold an executive session with you on what they think our options are. I'll be checking with them after tonight on what their availability is, but I hope it's sometime in April or May. And in the meantime, they sent us an engagement letter for their legal services. Nobody works for free. And that letter has been provided to you on dais tonight. It does require that the town provide a $1,000 retainer, and their billable rates are in there. So I'm looking for approval of this engagement letter. We will get billed monthly, so we'll be able to keep an eye on how those legal fees are going.
Questions or comments from the board? Trustee Counterman?
Wondering, engagement letters, so do we have to pay them anything up front to get the process started, or are we going to discuss that in a session?
They actually started the process already. I provided to them some of the public documents that I was able to get from the town of Hudson related to the establishment of their library. And they've already done an initial analysis and provided that to me, just to let me know that they do think we have some options. They are asking for a $1,000 retainer, and they'll bill against that retainer amount at their hourly billable rate, which is pretty standard to have to pay a retainer to lawyers.
Right, I didn't know it was pretty standard, so, thank you.
Other questions or comments? Trustee Morris?
Yeah, no comment, or no questions, but a comment. I think having a library, or at least pursuing a library for our town is important, and I think this is an important first step, and I am in support of proceeding.
Other questions or comments? I will entertain a motion.
I move we approve the engagement for legal services regarding potential Lock Buoy Library with Cedar and Vanderwall PC.
Motion and a second, roll call, please.
Mayor Lofgren.
Yes.
Trustee Ott. Trustee Jeffrey.
Yes.
Yep. And the motion carries five. Yeah.
I'm still here, yeah, yes.
The motion carries 5-0. Now we move to the discussion items. The first discussion item being the non-tributary well site proposal on the Neff property. Mr. Jeffers.
Thank you, Steve Jeffers from Lyons Gaddis again. I wanted to give you a little bit of history about this. I apologize, I put this map and the emails together very quickly to get in the packet, but I didn't really give you much background on this. In 1998, the town and Weldon Third Associates and Antonoff family and the Beebe Draw Water District entered into a pretty extensive settlement agreement that ended a lot of ongoing litigation. Some of it involved the High Plains development and water and sewer taps and use of the sewer treatment plant. As part of that settlement, the town acquired the local non-tributary groundwater that was owned by the Beebe Draw district that was part of the original augmentation plan to be used for the town. At that point, the district owned the alluvial wells that you now own. And they were supposed to be providing augmentation water with this non-tributary groundwater. Instead, they had an agreement with GASP at the time, which was a temporary augmentation plan that ultimately went away. But as part of this settlement, they conveyed the water rights under 3 parcels to the town, the non-tributary groundwater under those parcels. And they were supposed to also convey some well sites. I included a map that looks like this. Hopefully you all got that. Okay. So on that map, if you look at is yours a colored map? Okay. So the blue parcel that just says in Lock Buoy, there's 2 black dots there. That parcel was one of the 3 parcels, and you actually did acquire 2 well sites, basically where I've shown them on the map. Just below there is a little parcel that hangs down below Weld County Road 2. That's the Neff parcel. You were supposed to get 2 well sites on that parcel, but you weren't supposed to request them until something like 120 days before you needed to drill them, or until at least 5 years after the settlement agreement was signed. We waited 5 years, and then we asked for the well sites, and we've repeatedly asked for the well sites. And the concern by the Antonoff family was that they didn't want it to interfere with development of the property, so every once in a while we come back and ask for them again. We learned that that property now has been sold or is under contract and is being going through the development process in Brighton, and it's called the Ridgeline Vista PUD. We learned about that about the same time that we were talking to the potential buyer of some of the commercial property in High Plains, and we mentioned again to Mr. Antonoff that we would sure like to get those well site easements before that development occurs. So we have actually been working with Doug Antonoff on this. We've exchanged emails. I've talked to him on the phone. We actually met with him again today. What we're trying to do is find a way to get those well site easements. He does have that property. It's either been sold or it's under contract, and there's some concern that that might interfere with the development of that property. Part of the original 1998 agreement was sensitive to potential impacts to the development of the property, and that really was the reason that we weren't able to get those easements in the past. They were concerned that we might have to move those around. So at this point, Doug Antonoff is looking at our proposal to see if, as an alternative to this, we've suggested perhaps that the town trade some water under the 3rd parcel, which is the lower left on the map outlined in sort of a dark blue or purple line. That's what we call the money parcel. I don't know why it's called that. It must have been somebody's name, I hope. When you got the water under that parcel as part of the 98 agreement, there were no well sites to convey. The Antonoffs and the district did not own any well sites on that property. So we knew that when the deal happened. I've identified where the wells are decreed, and that's what these dots really represent, is the decreed location of the wells. So it's been difficult for the town to plan for the use of the water under the money parcel due to the distance from the town's wells. What we've proposed to Doug Antonoff is that two alternatives. One is if there's a way to give us the well site easements on the Neff property, then he can satisfy the current agreement. If that's a problem with him and the developer, we've suggested that we would have the town move those well sites off of the Neff property, and then you'd have to find another location to put them, possibly in parks or open space or other parcels, either within other parts of, across the road or in the Silver Peaks area. We want them far enough away from those other two potential well sites that they aren't going to interfere with each other. Same thing with the money parcel, the two wells that are there, we would, if we did a trade for some of the water under Silver Peaks, for water under the money parcel, we'd probably try to locate those wells on the Silver Peaks property somewhere on the city-owned land. As part of the background, in the 1998 settlement agreement, at the very end of that, there was some wrangling going on, and some feelings got hurt, some people got mad. The whole deal on the water rights almost fell through. To make the deal work, the owners of the Silver Peaks parcel said, look, rather than get in a fight about the non-tributary groundwater, they gave the Silver Peaks groundwater to the town to give to Antonoff, so that the deal wouldn't unravel. So that's how he actually ended up with the Silver Peaks groundwater, the non-tributary groundwater. So what we're asking them to do is to consider an exchange where the town would give approximately 147 acre feet under the money parcel in two aquifers to them, and forgive the well site easement requirement on the Neff property in exchange for all of the groundwater under the Silver Peaks property. That then consolidates the water up around the town, so that we would have to go to court. Yes?
Sorry to interrupt you. Would you restate that, what you just said? I want to make sure I absorb that and understand it.
Swap? Yes. Sure. So on the map, the Silver Peaks parcel in red, there was, that water was traded as part of the settlement agreement to the Antonoffs or to the BB Draw district in exchange for...
Is that the 313 acre feet?
Yes. And what we did is we said it's all the groundwater. We didn't know exactly how much it was. Because the town was saying they didn't want the 365 acre feet, the Antonoff and the district were saying, fine, give us back the 365 acre feet. To avoid having that deal fall apart, Bob Lemke and his group said, look, take the groundwater under Silver Peaks and give that to Antonoff and keep this deal going. So we said everything under that, including up to 365 acre feet. Chris has looked at this, thinks it's probably more like 313 acre feet. It's actually in 3 aquifers, though. There's a small amount in the upper Arapahoe, and then there's some in the other 2 aquifers. So it's a little more complicated to get all that, because you'd have to have 3 wells. You might need more than that, but you at least need 3 wells. So what we're proposing now, in order to consolidate this groundwater and make it easier for the town, and also to alleviate this concern for the developer on the Neff or Ridgeline Vista, is trade all of the water under the money parcel for all of the water under Silver Peaks, and waive those 2 well sites on the Neff parcel. So they're studying that to see if it will work. It would actually require an amendment of the town's augmentation plan, because the money parcel, the water there, is part of the augmentation plan. This is your second plan that you're not currently operating under, because you haven't yet constructed those non-tributary wells. And what we would propose to do then is to amend that plan, eliminate the money parcel water, include the Silver Peaks water, add some new well sites, and we probably even go for some more modern terms. It's a very old decree. It doesn't have all the things that you see in more modern decrees. So we try to get a well field concept so that you could pick and choose where you want to drill the wells, and you can pump all of the water through any individual well. It's probably not as important for you because we don't anticipate that these wells are going to be big producers. So it's not like you could really pull, 200 acre feet out of individual wells, but it's something that's in these modern decrees, and we'd probably do that. And we might also look to see if there are other sources of groundwater that the town owns, such as under Lake Henry and under Old Town. There's places that we could claim additional groundwater for you, maybe roll all that in together. So at this point, I have had discussions with Doug Antonoff and his lawyer, Alan Hill. They've engaged an engineer to look at the ability to combine the water under the money parcel with their existing decree. Everything else that's on this map that's shown in this sort of a pink color is part of the Antonoff's previous non-tributary groundwater decree, so this water actually fits in very nicely with that. But they're looking at that to make sure they're comfortable with it. They're also looking at it in terms of the numbers. That property, the Neff property, or these assets are all tied up in an estate right now because Gary Antonoff passed away. So it's a little more complicated. They have to look at the values and these things. So, but we're working as fast as we can with them to see what kind of a deal we might be able to make here. The fallback position is that they'll give us 2 well sites on the Neff property where they belong. But the alternative is this other plan to do a swap. And I expect to hear back from Doug at the end of this week as to whether they think it will work and how we might pursue a trade like this. And so we wanted to let you know about that and make sure that you were comfortable with our discussing this with him and pursuing this kind of a trade. Thank you.
I noticed you have this on for an exec session too. Would you prefer?
I think if you have questions that you think are sensitive, if they're related to negotiations, if you want to have that kind of conversation with me, we could go into executive session for those kinds of questions and answers. Sure.
Just had a general question. What started this? What motivated to start this process of doing all the switching?
To be honest, we started talking to them in 2016 about this. I brought it up with them because I felt for a long time that it would be useful for the town to get the groundwater under Silver Peaks, make some sort of a trade here. I had a meeting with Alan Hill and Gary Antonoff in 2016. We all got busy. It didn't really proceed very far. And then as we saw that this development was proceeding on that property, it became more urgent. So it really was my idea to do this. And I do think it's useful if we made this kind of an exchange.
Thank you.
Any other general questions? Seeing none, we will go to item B, which is also you, Mr. Jeffers, the status of case number 16 CW 3053.
Thank you. This is the trial that is set to begin on April 22nd. There's an application for a storage water right in the Highland Reservoir over here. There's a claim, I think it's about 4,000 acre feet of water. It's from both Local Supplies and South Platte Supplies. The original claims included some diversion points in town or around town close to Lake Henry and then going north, basically from Road 2 to Road 6 or perhaps even further. We got in the case for the town a few years ago to protect your land ownership at Lake Henry, to make sure they weren't going to try to construct diversion structures on that site without an agreement with the town. Also because of interest in protecting the wastewater treatment plant to make sure there wasn't any interference with flows there. I don't think that's really a concern because your discharge permit is probably at the end of the pipe there, so it's not as significant a concern. And there was also some issues about previous stipulation with United and others about making diversions between Road 2 and Road 4. And so we wanted to make sure that they honored that stipulation and didn't try to make diversions in there. Part of that was to protect Lake Henry, part of that is to protect the town's wells. And so we got into the case primarily for those reasons. We've been able to get some terms and conditions that are protective of those issues. We raised a couple other issues that we're still talking with them. We're going to be talking with them very quickly. And they've been tied up in other litigation recently. There was a FRICO case involving seepage out of Bar Lake that went on a very lengthy trial. They're battling each other quite a bit right now. There's a lot of discovery trial going on. And that trial just recently ended, so their lawyers haven't been quite as focused on dealing with us on these last few issues, but they did reach out to us and say they wanted to talk to us about those remaining issues. So we have only a small amount of time before that trial comes. We anticipate that we will be able to resolve these final issues with their lawyers, but we wanted to bring this to your attention. Last time we talked to you about another case, we mentioned our desire to develop some sort of a resolution or some sort of procedure where we don't have to always come back to you for approval of settlements of cases, but at this point we don't have that, and I think because of the way we've been talking about these cases, it's better to bring it back to you. Steve is aware of these things, but we are not asking Steve to make decisions unless we talk to you first on settlement of these cases. We have been working on a proposal to outline sort of his authority to do that, but I wasn't ready to bring that to you because I haven't given it to Steve and Maureen to look at yet. So I wanted to let you know about this. Given the time frame for this, there's one more meeting before the trial, but I prefer that if we can work this out, these are fairly minor details. If we can work this out on our own, we'd like to be able to go to Steve and get authority to settle from him rather than have to come back to you on 2 days before trial. Because we don't want to have to gear up for trial. It's expensive, and we think we can resolve this, and we think your money can be spent in better ways than that. So I'm hoping that you'll give us the authority to work with Steve to settle this case prior to that trial, if we can get those issues resolved.
Comments or concerns about giving Steve that authority? Trustee App?
I'm just
Playing with your record.
I'm thinking about something.
Anyone?
Okay, it makes sense in this case.
Okay, and I think this is also on for exec session, so if we have any legal concerns, we can raise them then. Thank you. Next item on the agenda is staff reports. Mr. Stamey.
Mayor, so a lot of the work activities have been working on your topics that you had on your agenda tonight. And I would, excuse me, comment that we just about have the 7-Eleven site plan all finalized. They're just doing a few tweaks to their submittals or to their final documents, and we'll get that ready. Then I think they still need to close from the applicant that's here tonight from Splains Group. And doing the ratification of that plat tonight will help that process move along as well. Excuse me. So if you look at the page 2 of the staff report, it's, Mayor Lofgren and Trustee Strzok have been involved in the DRCOG forums and meetings. So there's a table on the bottom of that report that illustrates or sets forth the funding sources for the I-76 interchange improvement project we've been working on, as well as the Greenway Trail we've been working on. And these would probably start design work in 2021 with actual construction in 2022. And the approval of the final funding goes to the DRCOG board later this spring, first part of the summer. So that's all, unless you have any other questions.
The only thing I would do is to follow up on that, just so it's on the public record, since we do have at least one member of the public, is tentatively we've received close to $2 million in grants for a trail system to run from County Road 37 to the new elementary school, and why did I just space out? Improvements to the interchange on I-76. So they will be formalized hopefully in May probably, and then we will be able to announce that. Any questions or comments for Steve? Seeing none. Any other staff reports? Anyone? Okay. Next up is Mayor Trustee comments. Trustee Jeffrey.
It was nice to break away from school for a little bit earlier today and meet with the new DOLA director, and I want to thank Deb and Linda for the nice lunch, because I know that took some work on your effort and I appreciate it. And I went to the library board meeting most recently, and there's nothing really to report. They've sort of gone into a process and been advised to like sort of put the brakes on stuff and go through and do some strategic planning on their part too. So
Stop spending money on parks while communities are asking for libraries.
Well, they still are moving forward with that park, and I didn't go to the open house. I was gonna try to, but I just couldn't get there last weekend, so I don't know how the turnout was.
Trustee Ott?
A couple things on the CML. The CML's given conditional support to Senate Bill 181. That's the oil and gas bill. They wanted the two things added back into the bill. One was elimination of the de facto ban on fracking, and the other one is allowing language for a citizen position to overturn. They got the de facto ban on fracking, but they didn't get the citizen position deal. So it's now back to the Senate again for them to concur with the House amendments. Also upcoming is House Bill 1257 and 1258, which is the start of the assault on Tabor. It sets up a ballot referendum on debrucing any Tabor limits and diverts them to transportation and education so they can make it sound good to the voters.
Good. What's CML's position on that?
CML's wait and see till they see what the bill actually says. And then there is a new building code requirement being drafted. It originally required when you update your building codes, you do the latest update that what's the building code?
International Resident.
International Building Code, IBC, that you do the most recent IBC as your update. That's since been amended that you can choose one of the last 3 IBC updates, so it gives a little bit more flexibility to towns so they aren't required to, big stupendous leaps. But that bill still has not been introduced yet. But as CML sees it at this point, they're on a neutral position till they make sure it's acceptable to the, it isn't forcing a lot of undue hardship on the towns to update their building code. And that's all I have.
Okay, Trustee Morris?
I don't have anything.
Trustee Connerman?
I just would like to say I'm glad to see that our events committee is advancing and that we have so many people interested in getting aboard with that. I'm looking forward to it.
And I have a couple things tonight. Have had a lot of meetings in my role as mayor in the past couple of weeks. Today, Trustee Ott, Steve, Maureen, and I met with Brighton Rec Center to follow up on the conversation we had several months ago at this point, about giving them money to participate in their events and being able to advertise them to our citizens. They were amenable to working with us to get an IGA that would guarantee our residents would be able to attend at resident rate. And they suggested a couple of big events that we could participate in for a first year just to see how it worked. The camp out event this summer, the trunk or treat, the turkey trot, and then one of the customer appreciation nights at the Oasis Water Park. So I think the IGA we're gonna work on will be $4,000 for this year to participate in those 4 events and be able to advertise them in our newsletter, on our website, et cetera, et cetera. And then we'll see how that goes and talk about whether we want to do it in a future year. So that should be coming to the board probably next meeting or the meeting after. So that's where we are with that. The other thing they suggested is we can actually reserve the Oasis Water Park to have like a lock buoy night where it's only open to our residents, and it's only like $600 to do it. So it's something we might want to talk about when summer rolls around. Let's see, what else? Oh, Trustee Ott and I met with the events committee on March 25th. Ms. Westcott was there, even though she hadn't been formally approved yet, as well as Ms. Huerta Cruz and Ms. Hoyt. And we kind of laid out some generic guidelines for planning the events, what they might look like, where they can plan them, and let them kind of have the world to start the ball rolling on some of this. They're looking forward to trying to plan a 4th of July event, hopefully in combination with Miss Lanter, and trying to figure out what we should do for the Fall Fest this year. We talked about the Easter egg hunt, and as you guys all saw in the newsletter, everyone was kind of in agreement that it was too late to do anything that we could successfully pull off this year. So hopefully we can bring that back next year. But in the meantime, several of the HOAs are hosting them this year, so that'll work. Also wanted to say thank you for the DOLA event today, and thank you to Linda and Debbie for putting together the lunch. I think that is all I had. Oh, yeah, go ahead.
The United Power Director meeting, the annual meeting and election meeting is April 17th, which is Wednesday. That's the night after our next board meeting. It starts at 4:30. We're all invited to attend. If you do, just get a hold of me and I'll give you the information to RSV to Jennifer Rodriguez at United Power. But we're all invited. They have a free dinner, and then a vote, and then they have prizes and stuff afterwards. It's a pretty fun event. Lasts till about 8:30, from about 4:30 on. But that's Wednesday, April 17th.
I think that is it. So with that, I will entertain a motion to go into executive session.
I move to go into executive session. Are we gonna do the second one or the first one? Both of them. For purpose of determining the town's position in matters that may be subject to negotiations, developing strategy for negotiations, and instructing negotiations under CRS section 24-46-402, parens 4, parens E, dedication of well sites on NEF or alternate dedication of town. And also for a conference with the town attorneys for the purpose of receiving legal advice on legal questions under CRS section 24-46-402, parens 4, parens B, water court litigation with United and authority to settle litigation on legal questions under CRS section 24-6-402, parens 4, parens B, water court litigation with United and authority to settle litigation.
Do
Mayor?
I have a second?
Mayor, just for purposes of your vote, I don't
I've
think
separated, no way.
Mr. Jeffers doesn't need any more executive session unless there's legal questions that somebody on the board will have. So you may not want to vote in favor of that motion.
Does anyone have any? So we do not need that motion if we
So I
have.
withdraw my motion
Excellent.
to say disappear.
Okay, so I think that is it then, and I will have a motion to adjourn.
So moved.
All in favor?
Aye.
All opposed? We are adjourned at 7:32 PM.
Lovely.
Yeah.
Long time.
Yeah, that was awesome. But I liked listening to Dave do the whole thing.
Thanks. Yeah, you should have been back there going like that.
He probably was, I wasn't looking up.
Thanks, guys. Thanks, Chris. Good. Good.
Or commiserations.
Thanks, board.